the wine.
He's got me beat. Let's speak last. Would you like practically?
Yeah, this is great. Hello, everyone. Welcome to the Constitution Center. So great to see you after I hope everyone had a wonderful summer. And it is so exciting to kick off our town hall season with this extraordinary group. You were very wise to come tonight because these are the greatest experts in America on the scope of the war powers. I think we're going to have some interesting agreement and disagreement about what the president can and can't do, and they will educate me and you about the scope of this crucial debate. This is going to be such an exciting year at the Constitution Center. On Monday, which is Constitution Day, we will have Ken Burns preview his new documentary about Vietnam. We will have David Rubenstein, the patriotic philanthropist, talking about founding documents, and Attorney General Rod Rosenstein will give a keynote address in the evening, which might or might not make some news. And then we will have this amazing Liberty Medal, where our chair, Vice President Biden, will give the Liberty Medal to Senator John McCain, recognizing a lifetime of service and valor and celebrating bipartisanship. And between those two events, there's just this amazing collection of authors and panels and discussions here and online and around the country that will be full of constitutional education. So thank you for joining all of it. Let us jump right in. I'm going to very briefly introduce our panelists and then begin our discussion. To my left is my old friend John Yoo, a law professor at Berkeley, the Emanuel Heller Professor of Law at the University of California at Berkeley, to give his proper title, and visiting scholar at the American Enterprise Institute. His new book is Striking Power: How Cyber Robots and Space Weapons Change the Rules for War. These are all old friends. So Ben Wittes has come from Washington to join us. He is Senior Fellow in Governance Studies at the Brookings Institution. He's now presiding over one of the most widely read legal websites in America, Lawfare, which has just exploded and is getting 1 million hits a year for people who are hungry for constitutional education. I just saw a vision of Ben's power when we went downstairs to see the James Wilson exhibit with Wilson's original drafts of the Constitution. And Ben tweeted Wilson's original crossed out drafts for the Impeachment Clause. The Constitution Center is nonpartisan, and so is Lawfare, but he's allowed to tweet what he likes. And he tweeted Wilson's original words, which were that the House shall serve as grand inquest of the nation. And within literally minutes, that had gotten hundreds of likes and retweets. So he has a great following. Professor Una Hathaway from Yale, unfortunately, was not able to join us because of an illness in the family, but we're so fortunate to have step in on short notice, a great friend of the Constitution Center and one of the great scholars of national security law in America, Deborah Pearlstein, professor of constitutional and international law at the Cardozo School. Deborah has participated in a series of podcasts and debates for the Constitution Center and has always illuminated us with her incredible insights. Please join me in welcoming John Yoo, Ben Wittes, and Deborah Pearlstein. So we're going to start in the present and then pull back to history. And the question of the moment, John, is urgent. Does the president have the unilateral power preemptively to order a nuclear strike in Korea? The Constitution gives Congress the power to declare war, but makes the president commander-in-chief. We know from the original Wilson drafts downstairs that the first drafts of the Constitution would have given Congress the power to make war, but that was changed to declare war. What is the implication of that change for the president's power to order unilateral strikes?
Well, Jeff, thanks for having me back, and thanks for waving my book.
Absolutely.
I didn't even bring a copy myself.
I'll wave it again.
Great guy.
It's great.
I got to hire you to be my publicist.
I'd be delighted.
It's great to be back in Philadelphia, my hometown. although I thought we were going to talk about whether to pull Mayor Rizzo's statue down, which is what I'm really interested in, having been a kid when he was mayor. And I remember when he would personally engage in riot control with his own billy club wearing a tuxedo. It was a famous front page picture in the Inquirer. Yeah, so I could see why people would want to take his statue down, I guess. So the short answer is yes, I do think that the president can order a nuclear strike or any kind of strike in North Korea, putting aside whether it's a good idea or not. I think the Constitution, when it made the president the chief executive and the commander-in-chief, gave him the power to try to stop threats on the United States. And we now have a country that has tested ICBMs, just exploded a hydrogen bomb, it appears to be, just 2-3 weeks ago, and has made numerous threats against the United States. I don't think Congress's declare war clause, one, requires that the president get the permission of Congress in this kind of situation where there's a plausible threat of attack on the country. But I also have a broader view that I don't think Congress's main check on the president comes through the declare war clause. I think it comes through its powers over the military and the funding power.
Great. Deborah, on the thought that you may take a different view, what is your view about the president's power to order unilateral attacks?
So on the question about the president's power to order a preemptive nuclear attack, that is, under current circumstances, it seems, I think the short answer is almost certainly no. My view about nuclear weapons is almost the same, with some caveats, as my view about the president's power to use force without congressional authorization in general, which is to say, the Constitution, the framers, the text, the history, and so forth, I think are pretty clear that the president was meant to have a limited amount of power without congressional authorization to use military force abroad. An amount of power that allows him to respond to sudden attacks, even that allows him to respond to truly imminent threats of attack, but that doesn't generally allow him or empower him without congressional authorization to go around using force for non-defensive purposes, right? Now, the reason I want to give two caveats here is twofold. Number one, the factual situation in North Korea and the circumstances there are unfolding very rapidly. The situation shifts on the ground a lot. The United States has, last I checked, on the order of 30,000 troops within a few miles of North Korea. So the threat to the United States, to U.S. personnel, can become imminent, one might imagine, at any moment, and that would change the constitutional calculus even under a very, in my view, original interpretation of the Constitution. The second caveat that I want to draw there is the use of a nuclear strike as opposed to any other kind of strike, right? So I think the most commonly thrown around scenarios about some sort of a strike against North Korea, envision potentially a conventional strike. We could certainly, with conventional weapons, degrade to some degree, to some significant degree, their ability to target a nuclear weapon or land a nuclear weapon in the continental United States or one of the U.S. Islands of the Pacific. And that would be arguably, when you talk about more within the realm of recent exercises of presidential power. But nuclear weapons are different for a bunch of reasons, including as a matter of law. We have a whole bunch of treaty commitments that are, by the Supremacy Clause of the Constitution, part of the supreme law of our land, part of the supreme domestic law as well, right? So the Geneva Conventions, for example, prohibit weapons that don't distinguish between combatants and civilians, right? You can't just blow up a whole bunch of innocent people. That's a violation of our treaty obligations. And those treaty obligations, in my view, are brought within the domestic constitution by the Supremacy Clause and limit the president's powers. So here, a preemptive strike, right? Not a self-defensive strike, but one that says, I'm tired of dealing with this, we're just going to attack now, I think would pose a significant enough problem under our existing treaty commitments that it therefore also imposes a constitutional problem on the president.
Fascinating. Ben, I don't know if you want to play the role of Justice Kennedy in this situation, but we've heard the view that the president does have the power to order a preemptive attempt and that he doesn't if it's not imminent, and there may be treaty constraints as well. What is your view?
Yeah, so I'm seated physically in between John and Deborah, and I think I'm going to answer this question the same way I answer a lot of questions this evening, which is it depends. And so let me say that the president absolutely does not have to wait until for Congress in order to act in defense of the country in the face of an attack, right? We didn't expect President Roosevelt when Pearl Harbor was attacked to call up the majority leader of the Senate and said, could you please, authorize the use of force? And similarly, if he had been lucky enough to have had 2 hours of warning about that and been able to scramble the planes in order to fend off the attack, you wouldn't have expected him to do that either. And that is, I think, a pretty good account of what the inherent authority of the president is, which is to repel an actual attack, and also inherent in that is the ability to fend off preemptively an imminent attack. And of course that raises the question of what imminence means in the context of a completely opaque regime that's been opaque to us for 70 years, does not operate according to rules that we have a lot of insight into, and in which the time horizon for repelling an attack is extremely short, right? Because nuclear weapons on missiles are by nature something that happens extremely quickly. And so I think the answer to the question, is it lawful for the president preemptively to strike at the North Korean nuclear program, depends in large degree on whether he believes in good faith that there is not merely a threat, but an imminent threat. And as a functional matter, I agree with John that he will, his order will be carried out, because no one's going to say, wait a minute, is he in good faith thinking that there's an imminent threat? So I think the military, he functionally has the authority to do it. And I agree with Deborah that the question ultimately of whether that's a lawful strike is really a function of whether, in retrospect, you believe he was acting in sort of raw power and in a sort of assertion of, the ability, a sort of because I can kind of logic, or whether there really was a belief that there was an imminent threat that he was repelling. And I think that's the basic parameters of the answer.
Thank you very much for setting up our debate so well. So let us now move from the headlines to history to understand the debate about the scope of the president's war power. John, you've written an important book called The Powers of War and Peace, the Constitution and Foreign Affairs, in which you argue that the framers did not understand the phrase declare war to amount to the power to make or commence war. Instead, declarations of war make public, show openly, and make known the state of international legal relations between the U.S. and another nation. And based on that, you argued that current practice, in which most of our military engagements have not involved congressional declarations, especially since the World War II, are in fact consistent with the original understanding of the Constitution. So give us your sense of what you think the framers understood the scope of congressional and presidential war power to be.
So I think that people who criticize a long tradition of war making by presidents in our history really do hinge their arguments on the declare war clause. And there is a popular conception that declare war means start war. And my view is in the 18th century it just didn't mean that. If there's a number of reasons why. First, if you look at the Constitution as a whole document, this is not the only place that the Constitution talks about starting a war. Article 1, Section 10. I hope you all brought your NCC pocket constitutions and are ready to look it up.
No, John, forgive me for this plug.
Or
has everyone?
I knew it.
Has everyone
You must
downloaded
have it
the
on.
interactive Constitution? You can't do it now because we're talking, but after the show, please go to the App Store and download the incredible NCC Interactive Constitution, and you will find the leading scholars in America on the left and the right writing about every clause of the Constitution describing what they agree about and what they disagree about, including the declare war
Or if
clause.
you have the Apple 10, you just look at it and it will give you whatever it thinks you want. So if I want a constitution, it'll produce it for you.
You should want nothing else.
And the robots will give us a better version than the one we actually have, I bet.
That's impossible.
So if you look at Article 1, Section 10, which I don't have before me either, it forbids the states from, and it doesn't say declaring war, it says from engaging in war. And then it actually has all the exceptions that Deb, I think, and Ben logically, reasonably want, which the Constitution actually doesn't have. So it says the states cannot engage in war without congressional consent unless actually invaded or imminent danger. So it even has the imminence clause in it. It has the actual invasion clause. So one question, it seems to me, is if the framers knew exactly how to write this very reasonable sounding system and say Congress gives its permission unless there's an attack or an imminent attack, why didn't they just repeat that and replace states with president? I don't think the framers of our Constitution were stupid. I don't think that they didn't realize the significance of differences of words. We spend a lot of time in Supreme Court opinions making a big deal of one choice of word over another, and they made a very specific choice. The second thing is that I looked at in the history is before the framers were all, if you think about it, they were all British citizens until the Revolution. Most of them were British lawyers before the Revolution. So I think they would have been familiar with the course of British constitutional history. They thought that they were rebelling against Great Britain because Britain was no longer following the British Constitution. So if you look up the 100 years before the framing of the Constitution, how many times do you think Britain declared war at the start of hostilities? Once. They were at war almost continuously. They attacked everybody in Europe in the 100 years before the Constitution. They only declared war once. The last thing about the history. The most famous declaration of war that everyone at the time of the framing would have known is the Declaration of Independence. If you read the Declaration of Independence, it actually parallels a declaration of war from that time of the 18th century. When did hostilities with Great Britain start? Did they start on July 4th, 1776? I don't know if we still teach in our schools anymore, but they started at Lexington and Concord in 1775. The declaration of war is an explanation, that's the main argument, it's a declaration of the grievances we have against Great Britain, what we have to do, why we're at hostilities, and then how we might bring a peaceful resolution. So to me, that meant declare war doesn't have all this weight that people give it. And instead, when someone like Alexander Hamilton, right, who apparently can rap now, so he's very popular in American culture, Hamilton, when he talks about why did they even have a president, under this system they're describing, you could just have a parliamentary system with a prime minister. Why have an independent president? It's because a president can act with speed and decision and secrecy, and Hamilton says, the two most important functions of the president are, one, the administration of laws domestically, and then two, the protection of the community from foreign attack. And so I think Hamilton, at least, thought when he was writing up the presidency, and he was a main defender of it in public, they were creating a different kind of system than a parliamentary system, the ability for the country to act quickly and decisively, especially in foreign affairs, which is very different than how the Constitution sets up domestic affairs.
Fascinating. All right, Deborah, John has made a very clear and provocative argument that the Declare War Clause allows Congress to authorize or commence a war like World War II or so forth, but does not require congressional authorization for lesser interventions from Syria to Libya. Do you agree or disagree? And also, was there a debate at the time of the founding between Hamilton and others who might have taken a broader view of congressional powers?
Yeah, so there's a lot in there, and I'm sort of trying to think about the list of things I wanted to say in response and the orders to do it. So it's fascinating from both a textual point of view and a historical point of view, because I think I disagree in almost every conceivable respect with what Professor you just said, but not in one. The one in which I don't disagree is the notion that this word declare war, right, means that's the only way wars start or something, right? As a factual matter, as a historical matter, that's certainly not true, nor did the framers think it was true. But let me back up as a matter of constitutional meaning and interpretation and say the Constitution actually says a great deal more about war and war power than just Congress has the power to declare war. And what I tend to do with my students in constitutional law is put up on the PowerPoint. Here are the provisions giving the president power under Article 2 that have anything to do with war, and it's like a short list, right? It's maybe 3 things, one of which is just the president is the executive, period, whatever that means, right? And then you have the list of powers under Article 1 that the Constitution gives Congress that have to do with war, and it includes not only declaring war, but regulating the military and paying for an army and a whole list of things, including regulating foreign commerce and a whole bunch of other things, defining and punishing offenses against the law of nations, that make it pretty clear what was historically completely apparent from the debate about are we going to say declare war or make war, and also apparent from the Federalist Papers and a whole bunch of other contemporary debates, that the framers wanted to give the president very limited power over war as compared to Congress, that the framers wanted Congress to have the lion's share of decision-making power over war. Now, that made perfect sense in the context of the history of the evolution leading up to the Constitution. The British system, the monarchical system that the framers were, of course, initially rebelling against, right, had the sovereign holding all of the war power, not only the power to make decisions to go to war, but the power to, in effect, appropriate money to go to war. Everything that had anything to do with war was all in the single power of the king, the single sovereign. The framers manifestly didn't want to replicate the powers of the king when they created the first government in the United States, the Articles of Confederation government. In fact, it's in the Declaration of Independence, a list of things they were angry with the king about, and one of them is he made the military, or to make the military higher than the civilian power, and a whole bunch of other things. So in the Articles of Confederation government, the United States, the very early United States, goes 180 degrees in the opposite direction. They give all of the power over war to the legislature. This creates the specter of General Washington, right, running back and forth to the Continental Congress every time he needed to know, could I take this hill, could I take that hill, right? By the time the Constitution is written, it was clear to the framers that we couldn't have all of the power vested in the king. This would be recreating the government we just overthrew, nor would it be all that effective to have all of the power in Congress because poor General Washington and his horse are going to get tired, right? So what they did was split the atom of the war power. They gave the president the power as commander-in-chief to, and even Alexander Hamilton, who was generally a proponent of presidential power and a great fan of George Washington in particular, even Alexander Hamilton said, we're giving the president to direct the course of the war once war is made by Congress, right? Now, the framers were also clear, look, this doesn't mean to deprive the president of the power to repel sudden attacks in the language that is most commonly quoted. War is made against us. War happens to us all the time, or could at least, right? We're not going to turn a blind eye to the way the world actually is. But the reason the framers changed the language from giving Congress the power to make war to the Congress the power to declare war was to try to draw exactly that distinction, right? In the event of a defensive or sudden attack that the president needed the power to respond to, he could shoot back without first asking Congress for permission. But in order to create wars, right, we wanted the opposite of the king, who could do that without democratic authority, without consulting the people, without asking us to vote. We're going to create not only limited Congress's power through calling it declare war rather than make war, we're going to create a whole list of other ways in which we want the people to engage in an elected, regular way through Congress in the decision about whether the country is going to war or not.
Justice Wittes, we have a clear disagreement about the president's power to act without congressional authorization. We also have the fact that, as John recently noted in his piece for the Philadelphia Inquirer, we've used force abroad more than 100 times in American history, but declare only 5 times. So tell us about your judgment about this debate that you've just heard as a historical matter, and then what about this practice? Is it or is it not consistent with original understanding?
It's like Justice Kennedy. Shouldn't we just start by telling him how smart he is, and good looking, and how all his past decisions are so brilliant before we
you're welcome
our
to
pitches.
do that. So in this case, actually, I don't find myself between John and Deborah. I actually completely disagree with both of them. But let me unpack that a little bit. So I think you have two basic observations. One is that Deborah is absolutely correct that the decision to initiate conflict is quite deliberately given to the legislature, and that's thought of as a restraint as residing with the people in some sense. And on the other hand, there is this inconvenient fact for that purpose. If you want to put too much weight in that, as John points out, there's this very rich history of presidents just kind of doing it themselves, and Congress not getting too upset about it, at least not upset enough to do anything. And the question is, how do you reconcile those two strains? Now, there's a few observations in that regard. One is that we talk about the founders as though they are a collective mind, and they are not a collective mind. Hamilton's views on this are different from Madison's. So if you look at Madison's behavior during the War of 1812, when he decides to go to war with Britain, which was a demonstrably deranged thing for the founder of our foremost constitutional father, the ultimate mouse that roared kind of thing. We had like 10 ships at the time, and the British Navy had 1,000 ships. I mean, it was a very crazy act. And so what does he do? He doesn't surprise attack Britain, which is, how you would think a small power might attack a great power. He goes to Congress and he asks for a declaration of war. And it's the most contested. People think the Vietnam War was contested in American history as a war. The resolution, the Articles of War, the Declaration of War against Britain in the War of 1812 was passed on literally a party line vote. And the response of the northern states, the Federalist-dominated northern states, was over the next 2 years to host a convention to discuss secession, which was not unnoticed by the young war hawk Congressman John C. Calhoun, who internalized it as a right of states to contemplate secession. And of course, that becomes a very fateful thing. The so-called Hartford Convention was actually a response to the British blockade of New England, so this is not the act of a president who believes, oh, I can just kind of initiate hostilities the way I want to, and then maybe we'll recognize that in some congressional declaration. Madison actually felt bound to do what Congress permitted him to do in the area of war powers. Now, on the other hand, you do, by the way, also have a remarkable number of congressional authorizations for very discrete, small uses of force against Indian tribes for decades and decades and decades. And things that we would think of as the equivalent of a drone strike in Yemen, right? Congress passes a resolution or includes in some authorization, by the way, go after this tribe over here in this region. And so I think the idea that Congress was not imagined to be a principal actor in the initiation strikes me as a little bit ahistorical. On the other hand, I I agree with John that people put too much weight in the declare war clause. And the reason is what the idea of a declaration of war actually means. So to me, the most interesting fact is not that we've only had 5 or 6 declared wars in history, but that we've had none since World War II. And you have to ask the question, why is that? It's not that we haven't had major wars since World War II. We've had, the Korean War was a big proposition, and the Vietnam War was a very long-term proposition, and we've been at war in Afghanistan for 16 years now. And so why do we not have declared wars anymore, and what is the residue of that authority? And I believe that the answer to that question is that the idea of a declaration of war is actually an instrument of international law. And we think of it as a domestic law thing because it's sitting there in the Constitution. But it's actually a proposition a state puts forward to invoke certain international law ideas, right, and international law states. And after the UN Charter is passed or ratified at the end of World War II, you're basically not allowed to declare war anymore. And so there actually have been no declarations of war, not just by US, but by anybody since the UN Charter. And so I think the best way to understand the modern relationship between Congress and the president in war powers is that Congress was given this incredible authority to do this international law act that we no longer use. And so the question is, what's the residue of that authority that Congress still has? And the answer is, it's morphed into this idea of authorization for the use of military force, which we used to embed within. It used to be that when you passed a resolution, declaring war, it would have at the end, and by the way, the president's authorized to do whatever he needs to do to prosecute this war. Now we lopped off the top half of that, and we just do the bottom half. And so that's one big effect, that the instrumentality that the framers gave to Congress is gone, and we just don't use it anymore. And nobody else does either. And then the second issue, which maybe takes us into the sort of more modern part of this conversation, is that the time durations associated with imminence have gotten very short. So it's one thing to say, if you're going to war against the British in 1812, and you've got all the time in the world, because even though they've got 1,000 ships, they're not right here. The closest of them is in Ontario and the sort of maritime provinces, right, and Quebec, in the St. Lawrence Seaway. But it takes them a while to get here, so you have time to kind of go to Congress and say, hey, do I have your permission to fight a war against the Lion? Congress can say yes, and then you can kind of muster an army before anybody gets here. But that doesn't really work if you're dealing with Kim Jong-un. And it actually doesn't work if you're dealing with the Soviet Union. And it actually doesn't work if you're dealing with, the Cuban Missile Crisis, right? And, or even a sudden attack on Korea, which is the first big, South Korea, which is the sort of first big conflict post-World War II, where this happens just all of a sudden, right? And and the time durations associated with modern warfare are so short that the ability to go to Congress becomes much more limited. So if you put those two things together, which is that the instrumentality that the framers really gave to Congress to initiate conflict kind of disappeared, and the time durations associated with presidential actions shrank a lot, and continue to shrink, because now we're dealing with cyber attacks, right, which happen in network time. All of a sudden, the sort of logic of the president going to Congress to ask for permission to prosecute a conflict really diminishes in vitality. And so I think the best way to understand the relationship between the historical war powers and the contemporary war powers is that Deborah's much closer to right than John is about where it comes from, and John is much closer to right than Deborah is about how it functions now.
Fascinating. Well, there's much to respond to in this three-way conversation, and Ben just phrased it very well. So respond to each other, but in the course of your response, John, responding to Deborah and Ben, take us to the next beat of telling us if Congress decided the president should be constrained, what constitutionally could it do?
It's a great question because it actually goes back to what I think really did happen in the framing. So Deborah's concern about the president going on military ventures was not something we invented after Vietnam. This was actually a concern that the anti-federalists had, the people who opposed the Constitution. In fact, at the key constitutional convention in Virginia, which was the key state that put the Constitution over the top, as it were, where the Constitution only passed 88 to 80. So 4 people voted differently. We wouldn't have this Constitution because there'd be no state where all the presidents would come from in the beginning. At that time, Patrick Henry was the leader of the Anti-Federalists. Remember, he said, give me liberty or give me death, and a lot of people wanted to give him the latter. He said in that convention, this president has all this war power. He's a king, and he's got an army, and he will suppress our liberties, and he'll go on adventures just like happened in England. So James Madison in Virginia is the leader of the defenders of the Constitution. He does not say, well, Congress has a declare war clause, so don't worry, he'll be constrained. No Federalist says that. The Federalist Papers never say that. It's really interesting. The only time you see mention of the declare war clause, Hamilton says, nobody declares war anymore. It's not really something we do. This power has fallen into disuse. We don't really need to talk about it.
I'm still a Hamilton.
Yeah, you are. You almost broke out into rap in your 10-minute soliloquy there. So Madison says instead, and this brings us to what Jeff wants to address, is Madison says, don't worry because the sword may be in the hand of the king, the purse is in the hand of the Parliament in England. And he says it's exactly the way it's going to work in America. And I think that's the main check then and now. Then it was a much more complete check for the reasons that Ben gave. The United States did not have a standing army of any size until 1945. And so if a president wanted to go to war, he couldn't. He had to go to Congress and say, not only do I want you to declare it, but I actually want you to build me a military so I can go to war. So the Mexican-American War of 1848 isn't actually fought for some time until the United States can build an army and a navy. And then we actually, for a border incursion, we launched an amphibious invasion of Mexico and captured Mexico City and deposed the president and took away the best third of their territory, which is a little disproportionate. Only after 1945 does Congress get in the business of creating a standing military. So they give up their check that the purse was such a complete restraint on the president. So ask yourselves today, do you think Congress wants to restrain the president from making any of these momentous decisions like using force in North Korea or Syria, where President Obama didn't get authorization, or Libya, where President Obama didn't get authorization, or perhaps might have happened in Afghanistan and Iraq unless Congress had voted authorization? Look at the shape of our military today. Is it a defensive military that's built for homeland security? You know, we're just 16 years ago was 9/11, and we discovered on 9/11 there are almost no fighter jets based in the United States that could intercept a civilian airliner because there are almost no fighter jets at all in the United States. Our military is built. It's called an expeditionary military. It is actually built to conduct offensive operations in other people's countries so that the war never gets here. Aircraft carriers are useless for homeland security. They're great if you want to put an aircraft base right off the territory of somebody else's country and use it to take under offensive operations. So I would say, in closing, if Congress really wanted to restrain the president, wanted to prevent these things from happening, they don't have to create a military that's designed for the offense. They could create a military that was just protective of the United States and then say, okay, if you ever want to go to war abroad, if you want to go to war in Syria or Afghanistan, then come to us and we'll build you that kind of military. And that would be a complete check. But Congress doesn't do it because they don't want to take the responsibility for making such a difficult decision. So what they do, and I'm afraid this is what happens in a lot of politics, they give the Congress transfers to the president a lot of resources, and then they say, well, that's the president's problem. If he wants to go to war or she wants to go to war, it turns out to be a bad war, all their fault. If it's a good war, well, we paid for it. And then the president is the one who's out on the limb and not Congress.
Great. Deborah, your response to what you've heard and your response to the question of what Congress can do to constrain the president if it wanted to.
Okay, so maybe let me start with the historical pieces and then come forward. First, and maybe least important, but I want to push back against Ben's interesting, but I think probably not quite right notion that the Declare War Clause in the U.S. Constitution was meant to capture an international law concept about the way wars were fought. It is certainly true the international law regulating the use of force or not regulating the use of force changed radically beginning in around 1928 and certainly after 1945, in that in the old world and at the time the Constitution was written, war was legal. You could invade other countries and take their territory, and the law thought that was fine, right? Wars of territorial conquest, what were called wars of aggression, what sometimes people still call wars of aggression, those were okay. And before states would launch wars of aggression, quite typically they would say, here's why we're invading you, because we think you've done something wrong, and now we're going to take your country and or at least some of your property, and this is how we're going to address our political dispute, right? The great revolution of the Peace Pact of 28, but more importantly, the UN Charter of 45, is to say it is no longer okay to use war as an instrument of resolving political disputes. And wars of aggression are not okay. Indeed, they're not legal. So sure, one state could conquer the territory of another state, but we're not going to recognize your lawful ownership of that land, which has largely worked. But all of that way post-dates the Declare War Clause, and to the extent there's discussion among the framers, and sure, all the framers have different ideas, although Madison was far more certain than even Hamilton that the president didn't have the power to wage offensive wars. The discussion amongst the framers about what significance declare war as opposed to any other congressional authorization to the president by legislation through both houses of Congress, signed by the president, to go blow up those ships, which Congress did quite regularly, was the difference between what was called a perfect war and something called a limited war. Right? Broadly speaking, a perfect war was something that engaged the entire population. Total war was another expression for perfect war. To do that, to do something like World War II, you needed a declaration, right? Most other uses of military force were going to be limited or imperfect sorts of wars, right? The kind of force that the United States and U.S. executives have mostly used. Now, to be clear about the history of presidential practice, those very early uses of force, of presidential force without declarations of war, and surely they did not come with, we declare war, right? Nonetheless came with congressional authorization to go do exactly what the president was doing. Indeed, congressional authorizations that tended to be written quite specifically, and that presidents tended to follow quite to the letter. And when they didn't, in cases like Little versus Bream in 1804, the Supreme Court said, this congressional authorization gives you the power to interdict ships going to France, but not coming from, even though the president authorized you to interdict the ships coming from France as well. That's beyond the scope of congressional authorization, and therefore he lacked the power to do it, right? So the early part of U.S. history is all entirely consistent with the notion that Congress doesn't have to declare war if it's not declaring war writ large in the sense of some perfect war involving all of the population and all of society, but it certainly has the power that the president is obligated to comply with, to authorize the president to use limited sorts of force for limited purposes, and the president does so. The real significant change in U.S. practice and in executive practice, because even the uses of force without congressional authorization are broadly speaking in defense of U.S. persons and property overseas, right? They're much closer to the core of defensive uses of executive power. The real sea change in our modern understanding of the president's power under the Constitution to use force without congressional action is Korea and Harry Truman in 1950, right? Post-World War II, for the first time, Harry Truman, with UN Charter authorization, right? He has all the power he needs under, all the authority he needs anyway under international law, but he still needs his own domestic source of authority. And Congress doesn't authorize the use of force in Korea. And there's no argument that what Truman wants to go do in Korea is, in effect, defend U.S. persons or property. What Truman wants to go do in North Korea, in Korea, is push back the communist menace, right? And he does that without congressional authorization. And it's from Truman forward, in other words, 5 minutes ago, right, that U.S. history begins to show this series of presidential action without plausible defensive, either imminent attack against the territorial United States or imminent attack against U.S. persons or property outside the territorial United States. It's Truman that launches the sea change. And then you see repeated exercises of presidential force without congressional authorization. And there are two last things I need to say about that. Even as you see this period of history of the last 50, 70 years now, of repeated uses of force without congressional authorization, you also see simultaneously repeated congressional authorizations and repeated actions by presidents to go to Congress and seek congressional authorization for the use of force. So it is hardly as though after 1950 the president says, oh, I don't need to go to Congress ever, so I won't. Right? Presidents continue to go to Congress regularly to seek both authorizations, large and small, for the use of military force overseas. So the notion that there's some uniform or utterly persuasive presidential practice post-1950 that should change our understanding of what the Constitution means, I think, is inexact. But it also goes to Ben's point about what the world is now like and what the functional demands of national security in the United States now require. It is certainly true, as Hamilton said, that the executive branch, in many respects, it's a harder argument to make today now that the executive branch is as mammoth and sweeping as it is, much larger than Congress. But it could be true still today that the executive has the ability to act with unity, secrecy, and dispatch in a way that engaging the other branches of government doesn't allow you to do, and that sometimes the defense of national security requires those specialized competencies. But Hamilton didn't mean his characterization of the executive's special expertise in that regard to be a policy recommendation. That is, anytime there's a security threat facing the United States or indeed any foreign policy interest, we should always act quickly and secretly, right? He wasn't trying to make a policy recommendation about the way we should generally carry out our operations, right? He just said, look, if we need to do this, the executive is better at doing this. And if you look at the past engagements in U.S. military, in major U.S. military engagements from the 1991 Gulf War, in the 2003 Iraq War, and the war after of course, invasion of Afghanistan after 2001 and so forth, all of these are circumstances in which the president did go to Congress and get an authorization for the use of military force, and those circumstances in which I disagreed with President Obama, in which recent presidents, President Trump, has used military force in Syria, or he has used military force in Libya, there was plenty of time for the president to go to Congress and seek an authorization for the use of force. And the reason presidents haven't done it, and this is a Democratic feature as much as a Republican feature of governance, is for fear, two reasons. One, for fear that Congress might say no, right? Which actually seems like maybe the proper functioning of a constitutional democracy, right? And number two, because, as John quite rightly says, while the framers had this notion, Madison especially, that the reason checks and balances would work is because everybody in the government would want power. You would have ambition in the executive and ambition in the legislature, and ambition would counteract ambition. And while the government was busy fighting itself, it couldn't do much to either interfere with our own liberties, right, or go to war elsewhere in the world, which the framers generally thought was a bad thing. The framers turned out to be wrong about that feature of human nature. Rather than having an ambitious legislature, right, a legislature that would want to assert its own power, we have had, since 1950, a legislature lacking all ambition, right? And just as the president has political incentives not to go to Congress because they think Congress might say no, Congress has political incentives not to demand the president come there because they might be compelled to say yes, right? Stop there.
Well, that is a common note that I've heard among all three of you, that although you disagree about the scope of Congress as checking power, you think that it is unlikely to exercise it in the current climate. I want to move to questions, and I'm going to pose the first one to Ben. Recently, President Trump threatened Venezuela with troops. They had not attacked us or were planning to do so. Does he have the power?
So I think the answer to that question is lawfully no. Now, could he concoct a legal rationale that there were some U.S. Persons or property that were threatened in that would be adequately plausible that the military would carry out the order? Probably yes. But I think in the absence of some plausibly imminent threat from a country that doesn't, I have no brief for the Maduro government in Venezuela, but I don't see a lawful basis for the use of force there. I do think I want to flag one founding era check on executive war making that we haven't talked about because it doesn't reside in Congress, and it's lapsed into non-use. And since you ask about President Trump's use of force in Venezuela or threats to do it, I think it's worth flagging. The reason that we're having this conversation today is that people are kind of anxious about the idea of President Trump with his finger on the nuclear trigger, right? That's the sort of subtext of this conversation. And that, although they couldn't possibly imagine the nuclear trigger, the framers did imagine that exact problem, which is, an impulsive, crazy person as president. And they actually designed a very specific sort of Hamiltonian model to prevent it. And we don't use it anymore. It's called the Electoral College. And the irony is that the Electoral College today is in disrepute because it doesn't allocate the vote according to the popular vote, which feels to us in a sort of profound way sort of anti-democratic. It was meant to be undemocratic in a much more profound sense than that, which is that the individual electors were individually entitled, and still are as a constitutional matter, by the way. They just don't do it, right? Because it's been supplanted by sort of a more populist sentiment and by the party system. But the individual electors were empowered to say, I don't care what my state said, I'm not voting for that guy, right? And that is unthinkable today. It's so unthinkable that when a few people floated the idea in the fall, it was regarded as eccentric and democratically disreputable, and they failed utterly to get any electors to sign on, or maybe one or two. And I think you have to think of that as it's not limited to war powers, but it's a very deliberate decision on the part of the founding generation to resist a kind of populist impulse. And by the time of the Jackson presidency, it is completely gone. And it never has a revival. But I think that's part of the answer to the question of, do you have a president in the first place who, apropos of nothing, says one day, I haven't removed use of force in Venezuela from the table, right? And everybody kind of shakes their head and says, what, right? And that's part of the explanation, part of the check that they built for that is the ability of the Electoral College not to consent to that person being in office.
Actually, I agree with Ben, but I think you got the wrong clause. So I think the power, I should have mentioned in addition, the other power they would have used to control a president like that would be impeachment. Not the Electoral College is
that one's the front end, the other's the back end.
Yeah. Impeachment, and so again, going back to the framing, it's a power we don't use very often, but impeachment comes from Britain also, and British ministers were regularly impeached for making mistakes in wartime, not even waging bad wars, but being dumb in the waging of the war. And so I think the impeachment clause is very interesting because we've come to believe it means you can only remove the president for a crime because the Constitution says high crimes and misdemeanors. But actually, if you look at the framers, they talk about impeachment as public offenses, which are much broader than crimes. And I couldn't think of actually something that would fit that better than waging an unwise war. And so I think that's another check that Jeff asked about that we hadn't talked about, but I think is also something, people talking about with President Trump, obviously these days. But if he were to wage war in Venezuela and it was a bad idea, Congress could always impeach him for that, it seems to me.
Deborah, I'm going to give both of these excellent questions to you because they're good and I want to get them in. Does the rise of non-state actors as targets of military action also help to explain the lack of war declarations since World War II? And where does the War Powers Resolution fit into this discussion?
Yeah, those are both really good. Let me, I guess, maybe try to answer it in this way. I don't think the rise, first of all, non-state actors have been a problem for the United States since ever, right? So they have more power now and they have the ability to wield more power now in part because of technological developments, right? Technological developments, biotechnology and lots of other kinds. Nuclear technology potentially puts greater and greater amounts of power in the hands of fewer and fewer numbers of people, right? So whereas previously it took a whole state to blow up another state, now you can theoretically do it with a much smaller group of actors. So there's no doubt that non-state actors are more deadly now. They've certainly existed all along. I don't think their rise explains the declare war problem per se for reasons that we've discussed otherwise. But it does create an enormous problem for the question of congressional authorization in general, right? So, for example, and the War Powers Act does this, is a wonderful way of discussing this problem. The War Powers Act requires two things, does effectively two things. One, it says anytime the president commits U.S. troops to hostilities or there's danger of hostilities abroad, it has to notify Congress, right? So don't secretly invade Cambodia or Venezuela or wherever it is, right? You have to notify Congress, and presidents have been awfully good, generally speaking, at complying with the War Powers Notice requirement. The second thing the War Powers Act more famously does is say, if after 60 days, you have committed troops to hostilities for 60 days, right? They're still there, and Congress is still capable of meeting and a bunch of other things, right? You have to come to Congress and get an authorization to have them continue to be there. Now, sometimes it's 90 days if the president asks especially as a favor, but that's the idea, right? Okay, if you have to repel a sudden attack or if some emergency arises or whatever it is overseas, we get that happens, right? But if you're still there after 60 days or 90 days at the outside, you have to come get an authorization from Congress. Presidents have not been all that great about complying with that, and Democratic and Republican presidents alike have not been all that great at complying with that. But it's not because presidents have said they think it's an infringement on their constitutional power, right? It's because they've made arguments, for example, like the one that President Obama made in defending continuing to engage in the use of military force in Libya back in 2011, right? We went in to stop the mass slaughter of civilians in Benghazi. We're there in a very limited capacity, right? But we're still actually blowing things up in Libya 60 days later. And some of the president's lawyers and Congress said, I think maybe you now need to get congressional authorization for ongoing operations in Libya beyond just the fact that we've continued to fund this activity, right? And the president, and through one of his very well-known lawyers, says, well, what we're doing in Libya, notwithstanding the fact that things are still blowing up, is not hostilities within the meaning of the War Powers Act, right? What the War Powers Act presidents have said, really trying to get at, were Vietnams. If what we're doing, right, tens of thousands of U.S. troops in the ground, American lives in danger day to day, risk of massive U.S. casualties, a long-term warlike affair, right? If it's something less than that, then not only do we not have to go to Congress and get a declaration of war, because it's not war in the constitutional sense of that clause, we also don't even trigger the War Powers Act obligation, right, to get authorization from Congress for continuing hostilities, because it's not even hostilities, right? And if you could say, dropping an occasional bomb from high above Libya, right, is not hostilities because there's no real danger to U.S. troops and there's no prolonged involvement coming by the United States. We're not contemplating a big war in Libya, right? Imagine how strong that argument would be if you were just making it with respect to, well, this is just a single drone strike against a single target in another country. And okay, next year we're going to do another single drone strike or a handful of single drone strikes. Or let's call it 2,600 people in countries outside of Afghanistan, Iraq, Syria. And where else have we been in war? Pakistan? The United States has killed 2,600 people as of the end of the Obama administration in countries outside of those war zones on the grounds that this is either part of some other war or that this just doesn't rise to the level of hostilities, so we never trigger a War Powers Act separate authorization obligation. Whether it's drone technology or other forms of technology, right, that make it lower and lower cost for the United States to use force abroad, cyber technology, right? You risk more and more of this kind of argument from the executive branch that has the effect of expanding its war power even further.
Great. Well, the only requirement of Constitution Center panels is that they end on time, but you now have some homework. The first is that Deborah mentioned this fascinating topic, which is the topic of John's new book, How Have Cyber, Robot, and Space Weapon Technology Changed the Notion of Imminence and Transformed Our Understanding of the War Power? Is Elon Musk correct that we should turn over war to the robots? To learn the answer to those questions, you've got to read John's book, so that would be great. And then, this is a very complicated question. And I want you're great lifelong learners. You showed up tonight to hear our incredible scholars. Educate yourself further about these questions. Listen to the We the People podcast, where Deborah and Cybercash debated the scope of President Trump's ability to send troops to North Korea. Go to the Interactive Constitution and read the competing essays by our two scholars about the scope of the Declare War Clause and the president's power. And as you read the news, approach it not from a political perspective, but a constitutional perspective. Because what you heard our scholars say is that President Obama was criticized for many of the same unilateral actions that President Trump is now criticized for. So decide what you think the right constitutional answer is, and then apply it regardless of your politics as you think about the right answer. Ladies and gentlemen, thank you so much for showing up tonight. Please join me in thanking the panelists. Wonderful. Nice. Thank you. Excellent. Very substantive. And I learned so much. Thank you so much.
Okay.
How long do you want these?